Alex here with part 107 of the My Docket series on child custody and visitation. As with my previous videos, I would like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed, cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the channel is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. 2 videos, guys. We are 2 videos away from another hearing. I know that those are the most popular of the My Docket series, so I just wanted to give you guys a heads up that in 2 videos, you will get another hearing video. And with that being said, we can go into my trial statement. I'm still not 100% sure that I needed to file a trial statement at this point because it's just an evidentiary hearing. Unfortunately, I don't know what the distinction is between the evidentiary hearing and the trial. I have like a 95% sure guess, and I discuss what that is in the video hearings, but I'm not entirely sure that it was necessary. I still filed one anyway, and in that filing, you're going to see very specific details that might seem like I just kind of pulled them out of thin air, but I actually didn't. I got them from the rules. Either the local rules or the rules of civil procedure, one or the other, and in those rules it tells you exactly what needs to go into one of these sorts of statements. So I think at this point in time, my mindset was mostly annoyed because what was the product of everything that happened? The product was that there's an attorney trying to get me sanctioned. And none of this would have happened if my ex didn't rack up 8 absences in a row. And this is just typical of the legal system of attorneys. You could be the one that's trying to do what's for the best interest of the child, and the other person, the other attorney doesn't care. It's not their job to care about the best interest of the child. It's their job to care about the best interest of their client. Again, I've stated in the video, Win at All Costs, that it's true if you told the attorney in sort of a bragging fashion that you are abusing the child, ha ha ha. Obviously, they would fire you as a client, but nobody really does that. No abusers do that, and the attorneys, it's not really their job to look into the veracity of your claims and intentions. Some of them do a little bit, especially if it's what they call a contingency lawsuit, but for all other intents and purposes, they just kind of take whatever you're saying at your word, and they represent you. Even if whatever you're saying isn't true, that's not their job. Their job is to scrutinize you. Their job is to scrutinize your opponent. Their job isn't to, check up on you. Their job is to check up on your opponent. Their job isn't to defeat you. Their job is to defeat your opponent. So that's how you can end up in these situations where you have an ex that's committing dental neglect, educational neglect, not taking the child to school. You try and stop it, put an end to it, go to court, and the attorney basically tries to sweep it all under the rug, get all the evidence thrown out the window, and then find a way to have you punished for trying to do what you're trying to do, which is protect the child. This is the reality that all of us face when we represent ourselves, and I think that this is probably, these last 7 or 8 videos are one of the most important videos of the series because it's going to teach you guys that what's right and wrong and what's moral isn't necessarily what's in the minds of the judiciary and the attorneys. They will say that to the public and to the media, but for the most part, it's a paycheck, it's a job, and they have a very specific goal, which is to win their case for their client. For the judge, for the most part, their specific goal is to stay on the bench, usually, not always. Sometimes they don't care. And the other thing that they're trying to do typically is to get the case going, get the case out, off their docket, whether that means disposing of it very quickly or whether it means punishing non-attorneys who bring things in front of them. They find ways to do this because of the mindset that I discuss in the video. End of filings is not end of abuse. It's another great video to watch. So at this point in time, we can go ahead and take a look at what I have filed. Here we have my trial statement. Scrolling down, I lead off with myself as the petitioner, appearing in proper person, which indicates to the court that I don't have an attorney, and then I am listing the 2 local rules that I am relying on in fashioning this trial statement. The first one is local rule number 5, WDCR, which is specific to Washoe County. And the second one is a family court rule within Washoe County, which is why the F is in there, the WDFCR 46. So these 2 rules are going to dictate what needs to go into this statement. First, I don't see why is this. I'm not sure that this needs a memorandum of points and authorities category. Again, guys, I'm not sure about the formatting here. This is back in 2012. I was still learning. And so, I mean, take this document with a grain of salt, I guess, and let's just go through it and see what I filed. I'm not too keen on telling people this is exactly how a trial statement needs to look because I really don't know at this point. Persons of interest in the first section. We have myself, the petitioner, my ex, the respondent, and our child, as well as Coral Academy of Science. Going into the facts. Now, these are broken down into the claim that I've made, the defense that my ex has made, and then the facts that are connected to this specific claim. These are very specifically outlined by those local rules. My suspicion now, all these years later, is that this has to do with stuff that is trial worthy. What I mean by that is certain issues that are either not opposed, so there's no defense to them by your opponent, or they are opposed, but there's no facts that need to be found out. In other words, they're just pure questions of law. Those sorts of issues don't really need to be resolved at the trial or at the evidentiary hearing. Those issues can be resolved by the judge by himself. Obviously, if something isn't opposed or if something is admitted, there isn't any sort of issue there. Your opponents admitted it, they agree, or they don't oppose it. Same thing. And the other sort of side of that coin is that there is a disagreement, but there aren't any facts that need to be found in connection to that disagreement. One side says this is the law, the other side says this is the law, and there's no facts to discover. So that's just a pure question of law for the judge to just decide on his own. There's no reason to go to trial on that. Anyway, that's my suspicion behind the point of that rule, and so we can go into it now. My first claim is that my ex neglected to take our son to school 8 times and is therefore guilty of educational neglect. My ex defends herself by admitting 7 of the absences, but claims that our son was ill. The facts that have to do with this are alleged in the affidavit that that the attendance keeper from the school filed or provided to me, and this would be something that would be trial worthy because this particular person would have to testify. Second claim is that my ex neglected to notify the school of the reason for our child's absences and is therefore guilty of educational neglect. My ex admits all 7 of the absences, but states that her defense is that she didn't know that she had to tell the school, which is silly. Then we have the facts, same fact. The third claim is that my ex notified the school of the reason for our son's 8th absence and stated that the reason was that our son did not need to go to school and is therefore guilty of educational neglect. You know, guys, I don't really need to bring up this educational neglect stuff. This is good, but you don't have to show educational neglect to modify custody. You just have to show that the best interest of the child warrant it. And in some situations, you have to show a change of circumstances. So this could say she's guilty of educational neglect, or that it's in the best interest of our child that, and there's one of the prongs there that discusses the child's education. Defense, this claim is not addressed as it was raised in reply. Okay. And the affidavit of Laura Turner supports it. Fourth claim is that my ex deliberately refused to submit our son's homework and is therefore guilty of educational neglect. And my ex does not defend the issue at all. She just doesn't talk about it. Facts are that homework is turned in on Monday. Our son is in my ex's custody on those days. Anyway, this would be dealt with probably with testimony and maybe with packets of homework. And we got fifth claim. My ex deliberately refuses to provide him with necessary supplies and is therefore guilty, etc., etc. Defense is that she fails to provide him with water. She asserts that he doesn't require a backpack. Sixth claim, deliberately refuses to follow the school's dress code and is contemptuous. And this would be something that probably falls under best interest factor conflict. It's a high conflict factor. And then there's another one that's failure to cooperate to meet the needs of the child. She doesn't oppose or address the issue at all, and we have the affidavit of the kindergarten teacher. I think here it would be better to put testimony by the kindergarten teacher and have her testify. But of course, I didn't know how these two things worked. I didn't know there was a difference between an affidavit in court and a witness in court. That's something I found out later. Seventh claim is that my ex deliberately disparaged me in front of choral personnel and is, see again, why do I say contentious conduct? This would be better placed under the best interest factor, parent most likely to facilitate contact with the other child, I think. Maybe under emotional abuse, I don't know. Defense, she doesn't deal with it at all. And then the kindergarten teacher's affidavit supports the claim. Next, we have claim 8, which is that my ex converted the uniform that I bought. Conversion, guys, is the civil counterpart of theft, which is the criminal charge. So in a civil case, you would typically say that somebody converted your property, not stole it, because that's criminal language. But anyway, this is not really, I'm not sure that this is relevant for this case. Conversion claim would go under a different lawsuit for money damages against my ex. It wouldn't be just kind of rolled up into this. But I think I could have still put it down in a different way. I could have probably put that down as failure to cooperate to meet the needs of the child. Again, I should have used the best interest factors, not necessarily all this other language that I'm using. Defense. My ex admits this and she says that she thought I just gave it to her as a present. The funny thing about this is nowhere does she say that that's the case. She never responds to me and says, hey, I thought it was a gift. She doesn't respond to me at all. And now that it's in court and it's in front of the judge, now all of a sudden she needs a reason. The facts, my ex admits it. Ninth claim, we have conduct that is likely to continue, potentially undiscovered, antisocial disorders previously. Okay, so this is the mental health stuff. My ex doesn't respond to it at all. All she really does is try to prevent it from being brought before the judge, which is a dirty tactic, but a tactic that appears to have succeeded in this case. And then we have facts. The court's barred discovery on the issue. So the court's basically going along with it. The court is saying, don't show me any of this stuff. I don't want to see it. Next, we have the undisputed facts. These are the things that my ex has not disputed, and we are in agreement. Again, this is something I recall being outlined in those local rules. So we have the 7 absences she admits, the conversion of the uniform she admits, conduct that she has not had any absences beyond the 8th. Okay, yeah, that's my admission that she hasn't done any more. She hasn't failed to take to school after failure number 8. And we have the admission that she's been submitting the homework every week ever since I filed the motion. And then we have the admission that her conduct towards personnel has greatly improved since the filing of the motion. This is all really good stuff. Issues of law. Best interests of the child are controlling, so it's good that I at least brought this up here. And pursuant to the law, you can modify custody based on the child's best interests. This is reinforced in Truax, which is the case, and this is again discussed in Mosley v. Figliuzzi, which discusses conflict between two parents and how the court should deal with those allegations. Educational neglect warrants a change of custody. We do have a specific law that says it's in the best interest of the child to have educational, well, actually it says developmental needs. And then we have a separate law, subsection 4J, that discusses parental abuse or neglect, which specifically, at least in this next section, cites education. So there's a couple of other statutes that are connected to this statute. Absent specific orders, the court cannot punish parental misconduct. This is true. The court cannot hold somebody in contempt unless they're in violation of a very specific court order, and this is discussed in this paragraph here, along with Cunningham, which discusses how important it is for that order to be very specific, and then this law, 22.010, which defines what contempt is. Here we have my ex's. So basically, I'm telling the court that since there's nothing in place, no kind of order in place for some of the stuff that she's doing, it looks like what I'm doing is asking for an order, at least in this section I am. Yeah, refrain from disparaging, non-disparagement clause here is what I'm asking about. Stuff that really doesn't matter that much. It would be better to use this as a basis to modify custody rather than to seek some kind of way to control her behavior. I'll talk about why that's not a good approach in the video, behavioral orders, and I talk about another sort of part of this problem in the video, gray areas. Take a look at those 2 videos if you guys haven't seen them. Improvement of conduct and the obstruction of discovery compels the release of certain claims. So because the court has basically interfered with my ability to get to the bottom of the mental health, and combining that with the fact that my ex has stopped the things that she was doing, I'm basically stating to the court that I'm forced to withdraw these claims because I don't have the opportunity to prove them anymore. In other words, the court has stripped me of my ability to prove the case by preventing me from getting that mental health evidence into the courtroom. Respondent is not entitled to attorney fees. So here I'm citing DCR 13.3. I think this is a technicality where I try to get her to ask for attorney fees in a separate motion. This isn't something that matters that much, and the courts typically have gone along with this approach where you just ask for attorney fees in the same briefing schedule. You don't do something later. And I think it does overcomplicate things. It's unnecessary, but that's what the court allows, and there's not really anything I can do about it. In this next statute here, we have the laws that discuss when fees are appropriate. And I've discussed this in the video, Defend Against Attorney Fees, so I'm going to avoid going over it again. We have the fact that I am entitled to costs. I'm not really sure if I am. There's this case that I cited that says that in cases of equity, costs are discretionary with the court. But who knows if this is true, and who knows what this is based on. What would have been better for me to do is to research this case down here, McGee versus Whitaker, and see what the context was. Because, I just really have no idea if any of this makes any sense. There may have been a statute back then that they were relying upon. There may be something in the common law that I don't know about. But this is like a 1939 case that is cited by a 1970s case. So for all I know, this isn't true anymore. Summary of schedules. I attached Exhibit 1, which is the Washoe County School District Rules. Witnesses. We've got the list of witnesses, which we already went over in this case, but it's the kindergarten teacher. It's another kindergarten teacher, a different one that's been sitting in every now and then. It's the attendance keeper here. It's the disciplinarian here. And then it's myself, and then it's my ex. Comments, suggestions, and alternatives. These go into some sort of miscellaneous issues. For example, my ex owes child support arrearages. My ex continues to refuse to pay the educational expenses. And my ex has admitted conversion of the uniform, and I'm entitled to the money. Certification of discovery. Let's see here. I certify that discovery has been barred by the court, so then there's nothing that we can do. So I wanted to conduct discovery, but this court has ordered that discovery is not allowed. And then we have a certification of settlement here, which is that I attempted to settle with my ex's attorney. I did send her an email, and it didn't go anywhere. And then we have the statements and documentary evidence pursuant to that local rule, and I certify that I have attempted to meet and confer, and she didn't do so. Declaration. By the way, guys, this is the way to do it. Don't just not follow the rules just because you know your ex won't follow them. Try and follow them, and then when they don't respond, which is what you're anticipating anyway, just note for the court, hey, I tried and they didn't do it. Declaration of, so this is my verification in support of this trial statement. I'm not sure if this is even required here. And then we've got local rule 5, which is how I'm serving this document, and I am serving it by personally giving it to my ex's attorney. We have a list of exhibits here. Exhibit 1 is the Washoe County School District Rules. We'll take a look at those really quickly. And this is the attendance policy of the school. And here we go. This states that absences that do not count against the 90% are, and here's the exceptions, but you have to call into the school to get these to apply. And then somewhere in here is the 90%, here it is, 90% attendance is required or you don't get to go to the next grade. And I guess 10% came to something around 11 to 14 days. I wish I could remember the specific amount, but I can't at this point. Here we have the subpoena from, what is this here? Oh, so this has finally been filed. This is the subpoena that went to the kindergarten teacher. Somehow, I guess I got it to her. I don't know how it happened, whether it was a school or not. You know, I think I know what happened. I think when that motion to hold the school in contempt was filed, they freaked out and made sure that she got the subpoena. And here is a certificate of Rule 5 service. Here we have the proof of the service of the subpoena. Okay, so this guy named Colby Stott, which is, yeah, this is the guy that worked at Coral Academy. So he served the subpoena for the teacher. That's what he did. Hey, so it worked, guys. My motion for order to show cause against the school actually worked. It got him to do what they were supposed to do, which was to get that teacher the subpoena. Pretty cool. I couldn't remember that. And we have here the judge's order vacating and resetting hearing. It looks like a conflict occurred. And so he moved the hearing to January 23rd, 2013 at 9 a.m. Certificate of mailing indicating that he mailed this document to me at this address. Going into the aftermath, I filed, let's see here, trial statement, subpoena, proof of service, 3 documents. They were all free filings though, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, let's see, I think she would have briefly reviewed the trial statement. I think 15 minutes maximum, probably less than that. Maybe she didn't even review it at all. Again, it doesn't require her to do any work. At least I don't think it does. I guess it could possibly give her a clue as to what to expect at the trial that was covered, the evidentiary hearing that was coming up. So 15 minutes I think is reasonable. The subpoena, probably nothing there, maybe a minute for her to review it and make sure that the teacher, now she knew, would be going to the hearing. Proof of service, another minute maybe, and then the order vacating by the judge will lump that into an additional 3 minutes, a total 5 minutes for those 3 documents, which is going to come to 15 additional minutes combined with the first 15 minutes from the trial statement comes to 30 minutes at the rate of $250 an hour. That comes to $125 in attorney fees for my ex. As for my previous videos, feel free to post any questions you have down in the comments below, and I will see you guys next time.